Hi everyone, my name is Doireann Ansbro, and as you'll have just heard, I'm the Head of Legal and Policy at the Irish Council for Civil Liberties. My presentation today is on international standards in judicial education and training. So I'm going to start by asking a question. Is Ireland complying with international law and standards on judicial training and education? And throughout my presentation, I'll try to answer this question. So I'm going to look at the international human rights framework, specific international standards on judicial training, what's happening in Europe, what's happening in other jurisdictions, training in Ireland, and I'll try and provide at least one answer to my question by the end of the presentation. So first I'm going to ask, why are human rights relevant to judicial education and training? Well, first of all, the overarching framework of human rights law provides a very clear requirement of a competent, independent and impartial judiciary to fulfill the right to a fair trial. And this is where ICCL's interest in judicial education and training in particular, but judicial standards in general comes from, is the need to promote and protect the right to a fair trial. So within that standard, you have that requirement of a competent, independent and impartial judiciary, which of course requires certain levels of training and education. Human rights law also imposes a positive obligation on the judiciary to both ensure equality across society and to combat discrimination, both in the way they exercise personal judgment, which ties in with impartiality, and by providing adequate remedies for acts of discrimination. In my view, the focus in Ireland has been on maintaining the independence of the judiciary, and we have a very highly regarded judiciary from the perspective of independence, constantly ranking very highly in terms of the independence of our judiciary. But I wonder, has the concept of impartiality and the positive obligation to ensure equality been somewhat neglected in education and training in Ireland? So let's just go back to this overarching human rights framework. So first of all, we have the Universal Declaration of Human Rights. And Article 10 provides that everyone is entitled in full equality to a fair and public hearing by an independent and impartial tribunal. We then have the International Covenant on Civil and Political Rights, which is binding on Ireland under international law as we've ratified this treaty. And in Article 14, it says everyone shall be entitled to a fair and public hearing by a competent, independent and impartial tribunal established by law. And then, of course, we have the European Convention on Human Rights, which is enshrined in Irish law under the European Convention on Human Rights Act 2003, which I'll come back to later. And under Article 6 of ECHR, we have everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. So we can see that this requirement of a fair trial has various factors. Going back to the UDHR, justice needs to be done in full equality. Looking at the ICCPR, we have the need for a competent tribunal, and then consistent across these treaties, you have the need for independence and impartiality. So clearly all of those requirements need training and education aimed at ensuring a competent, independent and impartial tribunal. What is impartiality? I think this is a really important question when it comes to training. The UN Human Rights Committee defines impartiality as the absence of personal bias and has called on states to give particular attention to the training of judges to enable them to render justice promptly and impartially. The European Court of Human Rights has defined impartiality as an absence of prejudice or bias. The court has gone further to separate this idea of bias into both subjective bias and potentially objective. And what they mean by subjective is that a judge mustn't be influenced by a personal conviction. And from the objective perspective, a judge must not give any indication and must give sufficient guarantees to avoid doubt that they are engaging in any form of prejudice or bias. Another form of impartiality is corporate bias, and this is one that is referred to by various legal scholars, including Griffith. And the idea of corporate bias is that because of their background, judges tend to have a particular outlook on life and a similar value system, which might lead them to decide certain types of cases in a biased way. Griffith has a striking quote, which is, "These judges have, by their education and training and the pursuit of their profession as barristers, required a strikingly homogeneous collection of attitudes, beliefs, and principles, which to them represent the public interest." So there's clearly a need for continuous training to combat these different types of potential bias, whether it's subjective, objective, or corporate. And part of that training should include training on the social context of the delivery of justice and diversity training. And we'll see an emphasis on social context and diversity training in later standards as we move on. Finally, before leaving the human rights framework, I would just highlight the positive obligation on the judiciary to combat discrimination. And this can be found not only in the anti-discrimination articles across the various human rights treaties, but also in particular in the UN Convention on the Elimination of Discrimination Against Women, which says that states must ensure through competent national tribunals, we have the competent again, and other public institutions, the effective protection of women against any act of discrimination. So that's a positive obligation to ensure the protection of women against acts of discrimination. And then under the UN Convention on the Elimination of Racial Discrimination, we have a requirement that states guarantee everyone equality before the law and in the enjoyment of the right to equal treatment before tribunals and all other organs administering justice, as well as the right to an effective remedy through competent national tribunals against any acts of racial discrimination. So overall, we can see that human rights law requires an independent, impartial tribunal, that it requires no bias, no perception of bias, protection against discrimination, positive obligation to promote equal treatment, and remedies for acts of discrimination. There's quite a lot there in terms of ensuring training and education address those issues. So moving on to specific international standards on education and training. Firstly, we have the UN Basic Principles on the Independence of the Judiciary. Now, these were formulated in 1985 for states to secure and promote judicial independence through the framework of their national legislation. They refer to independence, freedom of expression and association, but also to qualifications, selection and training, and various conditions of service. And these principles require UN member states not only to implement the principles themselves into their justice systems, but also to publicize the principles to the judiciary. So that's obviously a potential component of training and education as well. Of specific relevance under the basic principles is Principle 10, which holds that persons selected for judicial office shall be individuals of integrity and ability with appropriate training or qualifications in law. We then see the development of the Bangalore Principles of Judicial Conduct. And these, again, complement the UN standards, and they're designed to provide guidance to judges and a framework for regulating judicial conduct, and they have been endorsed by the UN Human Rights Commission. Judges under the Bangalore Principles are required to take reasonable steps to maintain and enhance their knowledge, skills, and personal qualities necessary for the proper performance of judicial duties. So we're seeing now this idea of the need for continuing education. Again, it states that this includes an obligation to keep apprised of relevant developments in international law and other instruments establishing human rights norms. So now we're seeing the need for focus in education and training of the judiciary on human rights norms themselves. So another principle that's relevant is Principle 5, which states that judges shall be aware of and understand diversity in society and differences arising from various sources, and goes on to list a number of protected characteristics. And finally, the measures for effective implementation of the Bangalore Principles, a separate instrument, holds that the training of judicial officers should be pluralist in outlook in order to guarantee and strengthen the open-mindedness of the judge and the impartiality of the judiciary. So again, we're seeing this requirement for training to combat potential bias, to ensure impartiality and open-mindedness. Just to focus again on various different standards, we have the UN Special Rapporteur on Independence of Judges and Lawyers, who has emphasized the need in a particular report to the General Assembly in 2012 for human rights knowledge and application by the judiciary and other justice actors for rule of law, to ensure the rule of law and to ensure respect for human rights. So again, we're seeing this need for human rights to be an actual subject within judicial training and education. We then also have the Latimer House guidelines. They were developed at Commonwealth level to protect the independence of the judiciary. And they provide that judicial training should include the teaching of the law, judicial skills, and the social context, including ethnic and gender issues. So coming back again to that social context. What's happening in Europe? So we also have the European Charter and the Statute for Judges. Again, we're seeing the requirements of open-mindedness, competence, and impartiality bound up with the exercise of judicial duties. And I think very interestingly, the EU Commission has published a European judicial training strategy for 2021 to 2024, which again really emphasizes this need to not just promote rule of law culture, but uphold fundamental rights, upscale the digitalization of justice and go beyond legal education and support the development of professional skills. And then it also talks about the need to combat unconscious bias as a necessary component of practitioners' training beyond EU law. It talks about the need for training on communication with and support for victims, and then goes on to emphasize the need for training on the rights of children, the rights of people with disabilities, and the adaptation of justice systems to these groups, as well as being the need for cognizance around the specific challenges faced by victims of gender-based violence, and the need for specialized training around equality and non-discrimination. And finally, in terms of Europe, we have the European Judicial Training Network, which works to promote training across Europe. And just as a matter of interest, in 2021, they've been offering training on human rights, freedom of expression and hate speech, freedom of speech in the digital era, as well as a range of other issues. So we can see these are kind of the cutting edge human rights issues of today that the judiciary is being called upon and will indeed in the future be called upon to make judgments on. So very briefly, in other jurisdictions, we've already seen these international standards being implemented. So social context is a core curriculum area in many jurisdictions. Subjects related to the potential for gender, race, age, and disability discrimination in the legal process have been implemented. Australia has gender training. New Zealand has training on disability and disadvantage. Canada has domestic application of international law as part of its training, as well as training on systemic racism and systemic discrimination. And in the US, training is being offered on implicit bias. So we can see these are just examples from these jurisdictions. Obviously, they offer training on a whole range of subjects, but we can see that these international standards are being implemented across the world. So very briefly, because I know this will be addressed in much more detail later on today, a look at what training in Ireland is looking like at the moment. So it wasn't until the Court and Court Services Act of '95 that a legal obligation was created on Irish judges to engage in further education once they joined the bench. But there's still no statutory framework for best practice and standards, and training is generally limited to conferences, seminars, bench books, limited induction, shadowing, and funding for judges to attain courses abroad. A Council of Europe report on the efficiency of justice in European judicial systems from 2018 notes that Ireland is one of only 3 states that do not provide continuous training. So we're clearly an outlier across Europe on continuous training. And I think it's very important to bear in mind the European Convention on Human Rights Act when we think about training and what a future curriculum would look like, because there is a legal obligation under Section 2, of course, that the Irish courts must interpret and apply the law in a manner compatible with the Convention provisions. And Section 4 requires judges to take notice of convention provisions and jurisprudence from the European Court of Human Rights, as well as the European Commission and the Committee of Ministers. And of course, if they are to take notice of these provisions and jurisprudence, ongoing training must be provided, as jurisprudence is, of course, developing all the time. Very briefly, just from our Justice Matters report 2007, there was a degree of judicial skepticism to training in Ireland that hopefully we are overcoming now. But it's quite striking to see what some judges explained in their interviews. Number one, there's been a degree of resistance and resentment to the notion of continuing education. This may be an obstacle that needs to be overcome. And secondly, in terms of human rights training, one judge said our education in terms of human rights would have been the study of fundamental rights in Irish law. A judge of the Superior Court said, I think I was lectured in constitutional law. And a judge interviewed from the Superior Court said that apart from Article 6, the right to a fair trial, and other convention articles in jurisprudence, other convention articles in jurisprudence were not of interest to him. And he explained that he arrived at this conclusion on the basis of his age and the fact that he adjudicated on mostly criminal cases. So this is obviously, if this attitude, I recognize this comes from 2007, but if these attitudes are still, there, or I won't say prevalent, but if they are still in existence, obviously work needs to be done to overcome such attitudes. Obviously, there's a lot of positive change happening, and that's partly why we're here today. The Judicial Council has been set up, and the Chief Justice Frank Clark in an Irish Times op-ed said that while previously there was little or no induction training, that is changing, and there are ambitious plans in place to greatly expand the training function of the Judicial Council, which of course is a very welcome development. We also have the annual report of the Judicial Council, which is providing much greater transparency and an opportunity for greater analysis in terms of what training is actually being provided. So finally, I promised at the outset an answer to my question, is Ireland complying with international law and standards on judicial training and education? So my answer is we are perhaps not yet meeting international standards of best practice on training, but change is happening, and hopefully human rights will be a cornerstone of this change. And to end on an optimistic note, the Chief Justice said in his Irish Times op-ed, building on what has been done to date, I'm confident that within a year, we will have made great strides towards putting in place a modern training scheme up to the best international standards. So with that, I'll end. Thank you very much for listening.